Hey, what's going on, everybody? This is Tim Lowe with Signature Real Estate Group back at you. Today we have Brooke Borg of Borg Law Group, and the reason why we brought on Brooke is because she's an estate planner, and man, does she's got the abilities to protect everybody in so many different ways, especially when they have assets. Just setting up for people that have children, the directives. There's just so many ways to be able to cover yourself once you do have assets, and your kids are definitely one of them.
That's right. That's
anyway.
it. Yes. Thank you for having me.
Yeah.
I'm excited to be here.
This is good stuff. We
Good.
like to do this kind of stuff.
Good.
But it's very important, I think, especially with everything that's going on with COVID, to go over everybody's possibilities. Everybody wants to push off estate planning.
They do. Yes.
And it's just one of those things that, I'm 30, I'm 40.
Yeah.
I don't really, what do I need to protect
Right.
for?
Right.
You know?
Well, let's be honest. Nobody's promised tomorrow. But yes, with COVID, it's become increasingly important for people to take a look at their plans and say, we should probably write this down in case the unthinkable happens. So we've been extremely busy since COVID. Typically, when people think of estate planning, they think of you're in your 70s or your 80s and you've got retirement assets. People with young kids, people with, that are just starting out need to come in too for planning. I always tell people, if you have $25,000 in assets, you need to do some type of planning because that's the level in Nevada that will push you through probate. Probate's a common word, but if anybody listening doesn't know what it is, it's the court process that you have to go through after you pass away if you don't have beneficiaries on your assets or you don't have a trust or properly planned so that court involvement is at a minimum.
Well, let's go through the probate process.
Sure.
Just so people don't, if you don't have something in place, you need to understand what's going to happen if you don't have directives of what's for those assets or for your children. So what's the typical process?
So I'll talk a little bit about before passing away because there's some things that could take place while people are alive that if they haven't properly planned, the court still gets involved, and that's with a guardianship proceeding. So a lot of times people think estate planning is just after your death, but it's not. We do estate planning for while you're alive. You've heard of a medical power of attorney.
Yes.
Somebody to make sure that someone's in place to make medical decisions for you if you can't make them yourself. If you don't have a medical power of attorney in place or a financial power of attorney, which does the same thing but for finances, we could be forced in front of a court to appoint a guardian for you to do those things. And it may not be your family. Sometimes they appoint companies to act in that capacity, and that can be a little bit scary. So there's documents that are part of an estate plan that you need in place so that if you become disabled, not just when you pass, but when you become disabled, you need those things in place too. And we do a lot of those, believe it or not, for kids going away to college. They're 18, so they're an adult, but they don't have anything in place. So, they're at college, mom and dad call the landlord and say, I need to talk to you about my son's lease. Good luck. They're an adult in the eyes of the law. So anyone 18 or over needs to have those powers of attorney in place if they don't want the court involved in making those decisions for them.
Well, that's wonderful to know.
Yeah.
It's,
You don't. No, especially for young people like that. You really don't think of it.
Yeah.
Our 18-year-olds are still our babies. They're our kids, but not in the eyes of the law. So we do a lot of that planning when kids are getting ready to go away to school. But I'll touch on probate as well, because probate is the process that when you pass away, if you haven't properly planned with estate planning for your assets to go to certain people or certain people to handle the administration, the court is going to get involved. So probates in Nevada, I tell clients, take anywhere from 6 to 18 months. And during that time, your assets are frozen and your family can't necessarily get to them without a court order. Also, it's costly. It costs your family money to pay attorney's fees and court costs when that money could have been given to your family, so.
Could have been used to set up
A plan.
prior to.
That's right. I always tell clients you're always going to spend less in estate planning than you will for probate. Probates I don't think I've ever done a probate under probably $5,000 to $6,000, and estate plan will not cost you that much.
Right.
Yeah, I mean, depending on who you go to, but generally it won't cost you that much.
I wonder, in the state of Nevada, is it backed up right now with COVID
Oh,
probate?
That's a great question. We just filed a petition and we got a hearing date of May. So if you filed something today to open a case, just to open it, you won't get on the court's calendar until the middle of May. So 2 months behind at least.
And if you say you own a property, how long does it typically take you to get through a process for probate?
Well,
once you're in the courts?
Good question. There's different types of probate. So depending on how much you own when you pass away, you could go through what's called a set aside, or you could do a summary administration or a general administration. Now those terms are foreign to people who are watching, but basically the more you have in assets, the longer the probate typically takes, and the longer you're in it. If you own a piece of property and it's in probate, there's a way that you can sell it through probate while you're in probate. Sometimes administrators choose to wait till the probate is done and then sell it once it transfers to the beneficiaries, but you could do either way.
Okay. Now, that versus if you have a trust put in place or something to that respect, how long does that typically take for them to be able to control the assets and be able to do what they want?
Yes, so as soon as they have a death certificate, they being whoever the trustee is that's named, they usually go to the attorney, have a new certificate of trust drawn up with a death certificate saying this person passed away, now I'm the trustee or I'm the manager of the trust. And they can start proceedings right away. They can enter into a purchase agreement on behalf of the trust. They can sell the property. Now, any debts or liabilities have to be paid, but there's no time constraints on selling the property if it's in a trust.
Okay. No, it's just
you
just never know. So in other words, everybody, make sure that you get yourself set up.
Yes.
And I think that there's too many parents that are like mine and a lot of other people, they don't want to talk about it.
No.
You know, it's not anything that you really want to have a conversation with your kids or with anybody else. It's kind of one of those in the back of everybody's mind, but it's just not discussed.
Yeah.
Well, put it in place because you don't want the state directing where your stuff's going.
No.
You know, you earned this stuff and it's been something you've accumulated over time. You want it to go to people that you care about.
That's right.
So make sure that you put things in place.
And I think the number one deterrent for people coming into an estate planning attorney is, oh, it's going to take too long and I have to gather all my documents and my statements and I have to find the deed to my house. We tell people, don't worry about that. Come in, we'll ask you all the questions we need to ask you, and we'll tell you if we need any of those documents later. But just doing that first step and getting in front of an attorney, they feel so much better just talking about it. Because in their mind, they've built it up like it's this really long, difficult process. And I can't tell you how many people have left our office and said, oh, that was so much easier than I thought.
Yes.
Yeah.
And she's actually helped us with processes in the past. And it's, man, it was a lot more simple than you really think it's going to be.
Good.
And
that's good.
So thanks for
Yeah, you're welcome.
So that's why she's here. She was just so helpful for us. Brooke's been doing estate planning for 21 years.
21 years this year.
Huge.
Yeah. Yep. I was part of the first graduating class at UNLV, so that makes me really old. The law school now is a quick funny story, is a beautiful building on campus, and when I started, we were at the Paradise Elementary School across the street from the main campus.
Oh, wow.
So they had converted the little people toilets to big people toilets, and our law library was the gymnasium, and now they have this big, beautiful building on campus. But yeah, I've been doing this 21 years.
So you were there in the 90s?
98. I started in 98, and the first class graduated in 01.
Oh, I was there in 93, 94.
Okay,
That,
all right.
that kind of
I just came right after you.
Yeah. Well, you know what? So I don't think everybody's situation is going to be different, and so she's got tools to be able to handle any type of situation. What if somebody just has a house, and just has a car, they don't have anything else?
Yep.
Do they truly need like a trust, or are there other documents that they can use?
There are definitely options. That's why we tell people, come in, don't go someplace that maybe they do a cookie cutter plan, or, by all means, try not to do it yourself because we end up fixing a lot of those. But there are options for people who have minimal assets, maybe a bank account and a vehicle, or maybe a piece of real property and a vehicle. Nevada is a great state to live in because if you have a beneficiary on anything that you own, we're not even looking at your will or your trust when you pass away. The asset automatically goes to that beneficiary. And in Nevada, you can put a beneficiary on anything. Wow. So you can put a beneficiary, people think of life insurance has a beneficiary, 401ks have a beneficiary. But here you can put beneficiaries on bank accounts. You can do what's called a transfer on death deed for real property. That puts a beneficiary on your property. And you can also put a beneficiary on vehicles here. So it makes it nice. It gives people options.
Is that a recorded document, or do you have to go to each individual situations to take care of that?
So you have to go to the DMV for the transfer on death for the vehicle.
Okay.
You have to record the transfer on death deed with the recorder's office, Clark County Recorder's Office, and then you have to go to the bank and talk to them about putting a beneficiary on your bank account. But some people would rather go that way. Now, everybody has a different situation. So I just talked to a lady yesterday who she wanted to do that initially, but I said, well, she had 2 sons. I said, if something happens to both of your sons and you want your grandchildren to get that money, you're going to have to go all those places and change the beneficiaries. It's ideal for somebody who has maybe 1 beneficiary or 2, but if you have a lot of different people you want to name or charities that you want to name, sometimes that doesn't work out and they're better going with the trust.
That's what I was just going to jump into. So I think in a trust situation, that's where that really kicks in. If you're trying to protect multiple things,
yes,
many bank accounts, stocks.
Right.
Well, stocks, I don't know if you
stocks can go in the trust. Yep, you can. You can put a beneficiary in stock.
That's why you talk.
That's right.
Because
That's
she
right.
can direct you on exactly where to take all this stuff.
That's right. That's right. Couple tips for your homeowners with real property is a great tool for asset protection is a homestead. I know you probably talked to your clients about homesteads and have in the past.
Can you clear up for us just so you guys get another
Sure.
heads up on what a homestead does?
Yeah,
Just give them
absolutely.
Yeah.
First question we ask if they own a home is, do you have a homestead? And the main reaction we get is, I think we did that when we bought our house, I'm not sure. A homestead is a declaration, a 1-page document that you file with the recorder's office here in Clark County. And everybody can claim 1 homestead, and it's on your primary residence. Once you file that document, and you're basically saying, this is our property, we own it, and we're claiming it as our primary residence. Now, you can have a mortgage on it, but you own it. Basically, the deed is in your name. You record it, and it protects your primary residence from general creditors up to $605,000 in equity. Meaning, it's not good against your lender, it's not good against the IRS, but anyone else who sues you, medical bills, credit card companies, lawsuits, if they try to force you to sell your home to pay off that debt, they're precluded from doing that. They can't make you do that. Now, if you have over 605 in equity, they can force you to sell your house, but you get to keep the first 605. I've never seen it go into place where they force you to sell it, but I tell people it's basic asset protection for your home, and it's, I believe now, $44 to file. So it's definitely worth it.
Definitely.
Everyone should have one of those.
Public record, right?
Yes,
The homestead.
public record.
Yeah.
Little tip though, if you refinance, sometimes the refinance will do what's called abandon your homestead.
Oh,
So
I
if you,
didn't know that.
so if, yes, and sometimes it doesn't, it's a mystery, but you do have to go to the Clark County Recorder's site and put in your parcel number, and it'll say if it's been abandoned after your refinance. If it has, you need to refile it.
Okay.
Mhm.
No, great tip.
Yeah.
Appreciate that.
Yeah, you're welcome.
So there's just a few things that Brooke hit on that she can help you with, but if you guys have any concerns with setting something up, and if you've got stuff that you need to protect, make sure to reach out to Brooke and her crew.
Yes.
So if somebody wants to reach out and get a hold of you, what's your office number?
So the office number is 702-318-8808. We have 2 offices. We have one that's on Russell in the 215 and one in Henderson on Coronado, Sutter, and Eastern. So we have 2 locations, or you can shoot an email to Brooke at borglawgroup.com. It's Brooke with an E at borglawgroup.com.
No, that's great. On your website, I'm sure you've got information on
We do.
each type of thing that you can help.
We do. We have information on our website, which is just borglawgroup.com, and there's also a way to contact us through that if that's easier.
All right. Well, thanks for coming out.
You're welcome.
Sharing all that
Thanks for
information.
having me. I love it. And you have a beautiful place here. So thanks for having me.
Well, thanks. Yeah, we try to hook it up here. So get the real estate group. We can even go play pool in the hall out there.
That's right. That's where we're going next.
That's right. Well, there you go, everybody. You guys got any questions, make sure to reach out to us and we'll get you taken care of.
Thank you so much.
Have a great day.